Hello everyone and welcome to our webinar on GP partnership agreements, the key considerations when updating your agreement. My name is Sophia Palmer. I'm an Associate Director and Solicitor at BMA Law. I've attained over 10 years of experience working for GPs and specifically drafting their partnership agreements. So just to give you a bit of background about us, we're an independent law firm established by the BMA, offering expert, cost-effective legal advice. And unlike other law firms, we offer BMA members a discount, and we aim to reinvest any surpluses back into the BMA for doctors. So just to let you know, this webinar is recorded and will be available after the session. The webinar will be split into two sections. There will be a talk given by me on partnership agreements and then a Q&A. If you have any questions, please type these in the Q&A box and I will try my best to answer these. If there are any questions that I'm unable to answer or I don't have time to answer, we can follow those up with you after the webinar. So please do feel free to contact me. My details will be on the final slide so that you can take these down. So when discussing partnership agreements today, we'll look at why having a partnership agreement is important and what the dangers are of not having one. And then we'll look at when you should update your partnership agreement and what the key clauses are to look at, followed by the Q&A. So to start, I thought it would be helpful to set out the definition of a partnership agreement, of a partnership, and that's on my screen. It's essentially the relationship that subsists between persons carrying on a business in common with a view to profit. So essentially, a partnership can exist even if there's no written agreement in place. So you don't need a partnership agreement to be a partnership. If you don't have a partnership agreement, you are operating as a partnership at will, and that's most likely to be governed by the terms of the Partnership Act 1890. Now, this is a very old piece of legislation, and some of the terms are unfavourable and not recommended, especially for GP practices. So it's also important to note that this is a definition of a general partnership, not a limited partnership or a limited liability partnership. This means that partners operating in GP partnerships have unlimited liability as opposed to limited liability. That means that you can be personally liable for any losses or liabilities of your partnership. So it's essential that you've got an effective partnership agreement in place that covers you all. The general partnership structure is the most commonly used structure and makes up around about 85 to 90% of GP practices. So why is it important to have a partnership deed? Your partnership deed is the legal document that governs your partnership. It sets out what you can and can't do, and specifically how you've agreed to operate in partnership together. It can also provide certainty on specific things, such as your profit shares, the sessions that you work, your shares in capital, and how you make decisions. Having a partnership deed also means that you're not operating as a partnership at will, and therefore not governed by the Partnership Act. And this can help you avoid costly disputes. There was one dispute a few years ago between two GP partners called Juma and Jones. The partners didn't draw up a partnership agreement when a new partner joined. The relationship turned sour, and a notice of dissolution was served to dissolve the partnership under the Partnership Act. The case went all the way to the Court of Appeal, where the judge held that the partners were required a legally binding partnership agreement, and they didn't have one. And that essentially, if you don't have an agreement, the partnership can be dissolved under the Partnership Act. Now, this case wouldn't have gone all the way to the Court of Appeal. It wouldn't have gone through all the processes that it went through, and the parties probably wouldn't have incurred the fees that they did if they had a partnership agreement in place. So it's always good to remember that having a partnership agreement, if anything, will help you avoid significant legal costs, hopefully. So if you become a partnership at will, you become governed by the Partnership Act 1890, which I've mentioned, a very old piece of legislation not tailored for GP practices. And there are several issues with being a partnership at will. The first is that any partner can give notice at any time to dissolve the partnership. A dissolution means that you're required or could be required to hand back your NHS contract. The assets of the partnership are then dispersed. You'd like to think that these threats of dissolution never happen, but they do, and they're often used in disputes. So where the partners have fallen out, it can be used as a threat to get what one of the partners wants. If a partner dies or goes bankrupt, the partnership is technically dissolved, which again puts your NHS contract at risk. The partners do not have the ability to expel a partner, so no expulsion clauses within the Partnership Act, which can cause an issue. So if there's underperformance or a partner who's not pulling their weight, you've got no ability to do anything about that or to get rid of them. All decisions by majority vote, so that sort of decision-making process isn't always suitable. You'll want in your partnership agreement majority decisions, unanimous decisions. You'll want to know how certain decisions are reached if there's ever a disagreement. Also, there are no leave entitlements, so no holiday leave entitlement, no maternity leave, paternity leave, or sick leave. It's always good to have those provisions in your agreement so you know exactly what you're entitled to. Again, there's no ability to suspend a partner. So if something's happened to a partner, say they've been suspended by the GMC, you've got no ability to suspend them under the partnership agreement, which can cause all sorts of problems. If you take on a new partner, there's no ability to subject them to a probationary period. So what you need in your agreement are provisions to deal with that probationary period, the length of the probationary period, and something to say that there'll be notice on either side, a much shorter notice, usually about 1 month, if the partnership is not working and you wish to expel that partner, not expel, but ask that partner to leave. There are no dispute resolution procedures. So if you fall out, there's no requirement that you go to mediation, nothing to help you resolve something that goes wrong. And again, after mediation, there's no pointer as to whether you go to arbitration or to court proceedings. Also, there are no retirement provisions in the Partnership Act. So if you're a partnership at will, you technically can't retire. And any exit, so if you do decide to exit, triggers a dissolution. This also means that a partner is not required to give any notice of their intention to leave, which can be an issue for succession planning because you want time to recruit. Also, there are no restrictive covenants. So once a partner leaves, you can't use anything to prevent them from competing with the practice, from poaching staff, from poaching patients, or do anything that they shouldn't really be doing. So we've spoken a lot about dissolution, and it's probably better for me just to give you a bit of a description as to what a dissolution is. So if a partnership is dissolved, the practice is wound up, the NHS contract is handed back, the assets of the partnership are sold, and your patient list is dispersed. In addition, if you lose your NHS contract, you also lose any entitlement that you've got to notional rent or rent reimbursement, depending on what you receive. And then you've got the issue of your staff. So you have to make your staff redundant if you can't move them elsewhere under TUPE, and the partners are ultimately responsible for the costs of dissolving the partnership. So that'll be redundancy costs and anything else. So when should I update my partnership agreement? I would say it's essential to review and update your partnership agreement to reflect changes in the partnership structure. So every time you take on a new partner or a partner joins, I would take a look at your agreement. There's usually something that could be done. I recommend that if you've not had any changes in your partnership, then you look at your partnership agreement at least once a year to make sure it's fit for purpose. If there are any changes that you're aware of, so any NHS reimbursement or anything like that, then you might just want to have a look at that or ask a solicitor or us to take a look to let you know if you need to do anything. If you decide to take on a new partner, you must update the deed before the new partner joins, so not after they join, which is often something that we're asked to do. If you don't update the deed before they join, the deed falls away and the partnership becomes a partnership at will. And this also applies if you've got a partner who's on a probationary period or mutual assessment period or whatever you want to call it, and that's because they are still technically a partner. So before admitting a new partner, you should ensure that the partnership agreement includes them as a partner, but also subjects them to any defined probationary period. So usually we see about 12 months if they've never worked in the practice before. And then also any buy-in and capital contribution provisions. That needs to be clearly set out. And you can have generic provisions for incoming partners so that when you do take on a new partner, it can sometimes just be as simple as adding their name, the new sessions and profit shares to the deed. Retirement planning should always be addressed in the deed as well. And we recommend that you seek legal advice when a partner retires to ensure that you've got the correct or appropriate provisions in there. You do not necessarily need to update the deed when a partner retires if they are retiring in accordance with the terms of the deed. So if they're retiring on slightly different terms, you come up with new valuation procedures or mechanisms, then speak to us and we'll tell you whether you need to have a separate deed of retirement. You should always ensure that your partnership deed is validly executed. So it's always worth checking when you have that little flick through every year to ensure that it's properly signed and witnessed by all parties. It's worth mentioning that an unsigned agreement may still be enforceable, but it creates an evidential and practical difficulties, and that increase the risks of disputes and legal proceedings. So just going on to some of the key clauses, some of the key considerations to look at when taking a look or reviewing a partnership agreement. Commencement and duration clause. This is a basic but very important clause. It specifies the effective date of the partnership. So you can backdate the deed to reflect the actual intentions of the partners. That's quite commonly done. Typically, the commencement date is the date on which a new partner joins, or the day following a partner's departure. So if this has happened in the past, you can still update the deed now and amend the commencement date to reflect the date on which the last change occurred. It's important that this clause also clarifies that a dissolution will not occur unless expressly agreed by the partners, because you don't want a dissolution to occur on, say, on any other terms other than those set out in the agreement. So say a majority vote if you want it to be unanimous. Another important clause is the clause dealing with partnership property. So if the deed does not contain property provisions, and some of your deeds may not, then it must be documented somewhere else, somewhere separate. And this is typically in a declaration of trust. So if you look through your partnership agreement and you notice that there aren't robust provisions in there, it may just be because they are in a separate agreement. We tend to like to have them in one agreement. The benefit of having a declaration of trust is that if for any reason your partnership agreement falls away, your declaration of trust does not. So if a new partner joins and you forget to update your partnership agreement, your declaration of trust will still be binding. So if your property is freehold, your partnership agreement should clearly state who owns the property and in what percentages, who is responsible for the upkeep, so internal and external maintenance, and it should have clear valuation provisions and how you go about getting that valuation if a partner joins or if a partner leaves. Again, if those aren't in your agreement, they could be in a separate document. If your property is leasehold, it's worth bearing in mind that only 4 partners can be named on the leasehold title. So a clause should be included to say that the lease is held on trust for all of the partners. Specifically, it should say that those partners, all of the partners indemnify those named on the lease for any expenses, losses, liabilities, claims, etc. That's because the claim will be made against those who are named on the lease. And if there are 5, there'll be 1 who is not. You may also want to think about having a sinking fund. And this is important where you've got repairing and dilapidation clauses or obligations in the lease. And it sets out who contributes and how much they're going to contribute, what it's for, what it's to be used for. And if a partner leaves, whether they're entitled to their share of that dilapidation fund when they leave. So you need to have quite specific provisions on that. It also means that the last partners, so that are in the practice at the end of the lease, aren't left with the covering the dilapidation costs when several other partners have had the benefit of occupying the premises throughout the duration of the lease. And you can come to us if you want to check if your partnership agreement has those clauses or not. I'm more than happy to take a quick look. So other key provisions, practice income and expenses. So it's essential that your partnership deed clearly distinguishes practice income from individual income. And also it defines what constitutes a partnership expense. So what we generally tend to see is practice income includes all revenue generated for the benefit of the partnership, such as NHS income, income from private work carried out during the usual practice hours, unless agreed otherwise, or locum work performed on behalf of the practice. So if you've got a partner who's stepping into the shoes of another partner while they're off sick, you may have cover agreement arrangement provisions within your agreement, where essentially that partner's working as a locum and being reimbursed for those sessions, those additional sessions. And then you've got individual income. So this generally includes private work undertaken outside of the hours of outside of the practice hours, and any personal, medical, legal work, anything like that that doesn't affect the practice itself or the operation of the practice. The partnership deed should also specify which costs are to be treated as partnership expenses, and which costs are individual expenses. So depending on how you operate, CPD, GMC subscriptions, BMA subscriptions usually all need to be separated into partnership or individual expenses. Ambiguity in these areas often leads to dispute. So having clear drafting from the beginning just ensures that you have transparency, fairness, and you don't fall out over something that can quite easily be resolved. Profits and losses. So it's really important that the deed sets out your entitlement to profits and your responsibility for any losses. If the profits and losses are shared in accordance with your sessional commitments, then this should be set out. In addition, if they're to be shared in any other way, we would recommend clearly setting out what the mechanism is for that, or having a memorandum or a schedule at the back of your agreement, which you can update every time sessions and profits and losses are changed. You also want to have a clear provisions on drawings. So when can they be taken? How much can be taken? Can excess drawings be taken? And what if a partner draws funds in excess of their entitlement? So you'll need very simple but effective clauses to say what needs to be done. So if someone's drawn in excess, when does that need to be paid back? Does interest accrue? Simple provisions like that. And then if you are in the fortunate position to take interim drawings, so excess drawings, when can that be done? Does it need to be on the advice of the accountant? And do the partners need to agree? And should that be a majority or unanimous agreement? Probably depends on how many partners you have. The larger the partnership, the less decisions you want to have as unanimous. So just the key decisions become unanimous. Also really important, and what we see a lot of are fixed share partners. So we see GPs as fixed share partners, practice manager, fixed share partners, nurse, fixed share partners. What's really important is that you set out what that fixed share is within the agreement, because it won't be anywhere else. And as their partners, it needs to be in the agreement itself. If they're receiving a fixed share, what about the losses? Do they have any responsibility for losses? And will that be in proportion to their fixed share? We often see these partners being referred to as salary partners, and we like to move away from that definition, purely because it blurs the lines between an employee who is usually salaried and paid on a PAYE basis and a partner who is self-employed. So we tend to refer to them as fixed share partners, and that is where they are clearly self-employed. Duties and obligations. So again, a really important clause, important to set out what the partner's duties and obligations are. And these may seem obvious, but where there's a dispute or where someone falls out, or someone does something that they shouldn't be doing, these are the grounds that you're going to be looking at to say that's a breach of the agreement. You haven't followed the agreement. You haven't acted in good faith, for example. So we have a robust list of duties and obligations in our agreement, but there can be things such as simple as you operate in good faith, you devote time to the practice, and you comply with all legislation and regulations. You think that that's all very straightforward, common sense, but when you need to prove that something's gone wrong or something isn't working as it should, you'll be looking at these duties and obligations to see whether they've been complied with. Importantly, you also need restrictions. So you need to be able to say what a partner can and can't do. And that's probably very similar to terms that apply to an employee. So, for example, any private work for personal benefit cannot be done during usual practice hours. And that's because they're using their commitment to the partnership for their own personal advantage. Things such as you can't take out a loan on behalf of the partnership or give a guarantee, and that can be in relation to lending, so lending against the premises. And you can't engage in excess spending. So having limits on spend is really important. And it just means that everyone will have oversight or the ability to know what's going on and what expenses are being undertaken. Okay. Decisions and meetings. So again, how decisions are made, really important clause. You'll need to set out which decisions are majority and which decisions are unanimous. And these are usually, the majority of decisions are usually the day-to-day running decisions that affect the practice. And sometimes you can delegate those, so you can delegate those to practice managers, you can delegate those to whoever you want. But you need to clearly set out which ones are majority, which ones are unanimous. The bigger the partnership, the more likely that decisions are going to become majority decisions. You can have a higher level of majority, so you can set, say, a requisite majority of 65% if you're not sure whether it should be unanimous or majority, but that all needs to go into your partnership agreement. And then you want your key decisions, such as perhaps the expulsion of a partner, the admission of a partner, anything really important, the decision to merge, to be a key decision and to be unanimous. Worth pointing out that expulsion, majority or unanimous depending on the size of your partnership, but exclude the partner in question from that vote. Because if you don't want to make it a unanimous decision, but then find out that they have the ability to block it, because that can cause all sorts of problems. The clause needs to set out how often you have partnership meetings, what's the quorum for a meeting, how many people have to attend. You'll find that partners are often on holiday, on leave, doing things outside of the practice. Therefore, having 100% quorum isn't always realistic. So maybe you want to discuss with your solicitor, maybe you want to discuss internally when deciding what the quorum should be. And then if you have a deadlock, so a vote that goes to a deadlock, is there going to be someone who has a casting vote? Sometimes that is the senior partner. Sometimes it's not. Sometimes the status quo just prevails, so there's no one with a casting vote. What we have seen is practices sometimes ask if they can delegate this casting vote to the practice manager who is not a partner. If the practice manager is not a partner, we generally say, don't give someone who is an employee and not a partner within the practice that casting vote. You want those who are responsible for the practice to be the ones who are making the decisions. Again, this clause is really important to revisit if a partner leaves or joins, and that's because you'll usually have a specific number of partners in the quorum section of your agreement, and you want to make sure that it all works as it should. And again, if you have a requisite majority, so a majority that's higher than a 50% majority, you want to ensure that those percentages all work if there's a change in the composition of the partnership. Also, you want to think about whether fixed share partners have decision-making rights, and if you've got practice manager partners, you might want to carve those out of clinical decisions. And we have specific practice manager clauses that we can include if you decide to make them partners. So leave clauses. It's essential that you set out the partner's entitlement to holiday leave, sick leave, maternity leave, paternity leave, adoption leave, even shared parental leave. The clauses need to set out who's responsible for the cost of the locum, whether they'll be entitled to their share of drawings and profits for the period of leave, so say if it's sick leave, and can the clause be drafted to take into account the NHS reimbursement and any top-up locum insurance policy that you have in place. As standard, our leave clauses, especially our maternity, paternity, adoption leave, sick leave clauses, are all drafted now to take into account the NHS reimbursement. So really important to have that in there, because it sets out who is responsible for the shortfall if there is one. Um, Also, if a partner is on an extended period of leave, so say they've been on sick leave for a long time, you may want the ability to expel or ask that partner to go. Um, what you have to be careful of here is disability discrimination. So if you do have that clause in your agreement, the compulsory retirement clause, then we would say seek advice before you exercise it. Make sure you're going through the right steps, the right stages, and you've taken into account everything that you should. And you've weighed up the risks of doing so, because quite often it can be argued that if you're expelling someone because they've been off sick for more than 12 months, you do run the risk of a disability discrimination claim. Usually we see 12 months there because that's when the NHS reimbursement or any local reimbursement that you have expires. So following on from that, one of the most important or interesting clauses to think about is the green starts clause or your expulsion provisions. So it's really important that you have robust expulsion provisions. You should have a list of grounds for expulsion, so a clear, strong list of grounds for expulsion. And in addition to that, you may wish to have something called a green starts clause. And that essentially gives you the ability to expel a partner without having to justify it, so without having to really give a reason. We don't recommend having a green starts clause unless you're in a partnership that's at least 3 or more. The reason why is because it can be used by, say, 2 partners to gang up on the other. We definitely don't recommend that you have it in a 2-partner practice. That's really not ideal. But I would say always speak to a solicitor, speak to us. Make sure that if your partnership is increasing in size, make sure your expulsion provisions are fit for purpose. Make sure that you're considering the green starts clause and perhaps having it where you don't want to run the risk of a discrimination claim, where you don't necessarily want to have to prove that someone's done something that they shouldn't be doing. It gives you a simpler way to expel a partner. But you just need to be careful about how you exercise it and when to include it within the agreement. You also want to have a clear dispute resolution clause, so something to say how you resolve a dispute if one occurs. Importantly, you need a clause to set out how partners leave the partnership. It's not something that's in the Partnership Act, so you need clear provisions within your agreement. The agreement should say how much notice a partner needs to give. So we see anything between 6 to 12 months. What we tend to see now are sort of longer notice periods, so closer to 12 months. And that's because it's getting more difficult to recruit, and practices need time to plan. They need time to recruit and plan for the exit of a partner. You need to consider whether another partner can retire at the same time. What you don't want is a rush to the door, so several partners leaving at once. So you'll need a clause in there to say if notice is handed in at the same time by 2 partners, who goes first? And this is entirely up to you. It can be based on service, so the partner who's been there the longest. It could also be based on who is older, but you might want to consider whether that has any age discrimination implications that go along with it. And it probably will depend on how the clause is drafted. So you also want to look at if you can stop a partner from retiring. So not only do you have you can't hand in your notice at the same time as another, you might want something to say only one partner can serve notice in one accounting period. And then you also want to think about if this situation applies to you, having a last man standing clause or a last partner standing clause, and that essentially prevents a partner from being the last one running the practice by themselves. There are several ways in which you can draft a last partner standing clause, and we can go through those. I can even look at your partnership agreements to see if the ones that you have are effective. But what we tend to see are option provisions. So if a partner leaves, there's an option to buy out the outgoing partner. The remaining partners have the ability to decide on whether they want to exercise that option, so that option to buy out that partner, or with whether they wish to say, actually, no, I don't want you to leave. We're going to wind up the practice. We're going to dissolve and wind up. What that does is that's sort of the nuclear option that pushes you to dissolution and winding up straight away. What you might want is something to say that where the partnership falls below, say, 4 partners, and a partner hands in their notice, that notice will be discussed at a meeting, and the other partners will have the ability to decide whether they want to postpone that notice or allow that notice. If they choose to postpone the notice, then they can postpone it by, say, 6 months and use that 6 months to see if they can recruit. If they can recruit a partner, they allow the retirement. If they can't recruit a partner, then they move towards discussing an expulsion. Not an expulsion, a dissolution. So important clauses to consider, but you need to make sure that they work for you. You also need clear buyout provisions for when a partner leaves. So this clause should set out when the leaving accounts are prepared, and when the exiting partner is paid out for their share. If they're not paid out, does interest accrue? If they're a property owning partner, do they continue to receive a share equivalent to notional rent? How does it all work? So it's important to have that set out. Quite often we see disputes relating to outgoing partners because they haven't been paid out, they've not been paid out what they expected, or they've not been paid out on time. The clause should also cover what happens if the leaving accounts are disputed. So there should be a clear dispute resolution process. And we always recommend running the leaving account provisions by your accountant. Really important to make sure that they are watertight. Importantly, as part of the buyout provisions, if your property is freehold and if you have property owning partners, you want to ensure that you've got a valuation provision in there to deal with how the property is valued when a partner leaves or even when they join. And we can help you with those clauses. Each clause is specific to the practice, so they need to be looked at and reviewed to ensure that they're fit for purpose. Finally, the clause that usually follows on from when a partner leaves are restrictive covenants, so restrictions on outgoing partners. These are important because they protect the interests of the practice. They include things such as you shouldn't compete with the practice, you shouldn't poach staff or poach patients. One thing to note on this is that if you're to enforce them, they must be proportionate for protecting the legitimate business interests. If you ever wish to seek to enforce this clause, we always say make sure you seek legal advice. The reason why is because they're usually very difficult to enforce, and they're generally there to act as a deterrent unless you have a very, very good reason for enforcing it. Again, if you have a practice manager partner, you can include these clauses for a practice manager, but they need to be tailored for practice managers, and we can help you with that. You also want to include, just briefly speaking about practice managers, specific provisions for them. So often, because a practice manager isn't involved in the clinical side of the practice, they often want to be indemnified in relation to, say, clinical claims, clinical decisions, things that they have not had any responsibility for or any input on. So having a clear indemnity for practice managers is something to consider, and it protects them from any liability that they don't or shouldn't incur. So that brings me to the end of the key clauses. I think what I've done here is I've set out a brief clause on why you may want to use BMA law. We offer competitive rates for first draft work and amendment work. We are also running a limited time offer this summer where we complete your agreement from start to finish for a fixed fee of £2,495 plus VAT. And that's on the assumption that it finishes within 4 months of us sending you the first draft. So if you want to find out more about that, please do get in touch, or you can even pop your name in the Q&A or the chat, and I can get back to you. It's worth mentioning that we have specialist lawyers who deal with partnership agreements, so they'll be with you from start to finish. We specialise in advising medical professionals, so we've got a deep understanding of the specific requirements and drafting requirements for GP practices. And we also provide a variety of other partnership-related services. So we try to be that one-stop shop for your GP partnership needs. So, for example, usually when there is a change in partnership, there'll be a change in the property, whether that's a sale of their share of the freehold or an assignment of the lease. And we have a property team who can help you with that. It's really important to get that done and for it not to drag. The deed should also include clauses to say what happens. What happens if that is or isn't done. It should always be done if possible, but for a lease that may not be possible if there's a requirement for a certain number of partners to remain on the leasehold, the lease. So we include specific indemnities for that, but you can speak to us about that in more detail if you need property provisions. And we also offer a mediation and dispute resolution service. So for any reason you need us for a fallout or something else, you can get in touch. We offer GMC, CQC, regulatory advice, and other personal services as well, such as conveyancing, wills and probate, and family law. So another thing to mention is that we, for anyone who has attended this webinar or watched it at a later date, we're inviting you to attend a one-off partnership agreement consultation, which is free of charge, and it's where you send me your partnership agreement or let me know what your specific circumstances, and I will take a look and give you my thoughts. I can let you know what needs to be done, if you've had any changes or if you've got any upcoming changes. So that's a consultation, usually lasts around about 15 minutes, and you can book that in with me if you wish to do so. You can either pop your name in the chat or in the Q&A. Just let me know that you want a consultation, and I will book you in for one. So that brings me to the end of my slides. My details are at the end, so please do take a note of those and drop me a call or send me an email if you've got any questions. What I will do now is I will just run through some of the questions that have been posted in the chat box, and I will see if I can answer these. If there are property questions, I may have to defer these to my property team, so bear with me while I take a look. But the first one is, do I need a deed of retirement if a partner leaves? So it depends on your partnership agreement. If you have a valid and binding partnership agreement and it's got robust retirement provisions in there, and that partner is exiting under the terms of those retirement provisions, then you don't necessarily need to update your deed. You may wish to update it for housekeeping purposes, so you may wish to take their name off the deed, but you don't necessarily need to do so. And that's because the deed will continue to bind the continuing partners once a partner goes. But what I would say is, if that is occurring, send it on to us and we will take a look and let you know. If a partner is retiring under terms that are not within the deed or slightly different terms, then I would say put a partnership agreement and put a deed of retirement in place. And also, if you don't have a partnership agreement and someone's leaving and you don't have time to put a partnership agreement in place, then put a deed of retirement in place, because the deed of retirement will govern the terms of those exit. It will set out when that partner goes, when they're to be paid out, and what they can and can't do after they leave. If there's been some form of dispute in relation to the outgoing partner, then you may want something that is similar to a deed of settlement or a deed of retirement and settlement, and you can have provisions in there to cover the dispute if one has occurred, and something perhaps to say that the dispute finishes there. So a clause to say in full and final settlement, and that means that the dispute stops there. You can't then bring a further claim or issue. So one of my partners is refusing to sign the deed. Is it still binding? So in order for a partnership agreement to be binding, the partners need to sign the deed. So the deed needs to be dated and it needs to be signed and witnessed. I suppose the standard position there is, if it's not signed, the easy thing to say is, well, it's not binding. But then what you've got to do, if there ever is a dispute, is look at, were there certain provisions in that agreement that everyone had agreed to, and could it be implied that all the partners intended for that clause to be binding? So there are It's not always sort of straightforward. There are sort of grey areas and points that can be argued, and it all depends on the facts. So what we would need to do probably is look at the circumstances. So why that partner isn't signing the deed, where you've got to with agreeing the terms of the deed, and then we'd probably be able to give you some advice based on that. The next question is, can you please explain the last man standing clause? So, as I said, there are two ways of doing this. Well, there's probably more than two, but we have two methods. The first one is the option clause, so an option to buy out the outgoing partner. You can also have an option to force the continuing partners to buy your share. Not really seen so much. So basically, two-way option. But if you're looking for those last man standing provisions, then what you want is an option. The remaining partners to have that option to buy out that partner's share. If they don't exercise the option, the partnership is dissolved. And then you can have the provision say where the partnership drops below a certain number of partners, the continuing partners will have the ability, the option to consider whether they wish to accept that retirement or delay that retirement, postpone that retirement while they look to recruit. Okay. So I've got a question about if the property is owned by partners, there is a multiplying factor to decide on property value when one partner is retiring. Does this multiplying factor change? So it depends how that works. And I think what we'd need to do with that question is have a look at how your valuation clause is drafted. It sounds as though it's quite specific to the partnership, because having a multiplying factor isn't standard. So it'd be interesting to see those provisions, and then we could let you know how they work, whether they should be working if someone's joining, and in addition to when someone's leaving. Our last partnership agreement was in 2007. Okay, in that case, if it was 2007, I would say you definitely need to consider updating your agreement. There's been so much that has changed since then. I mean, it most certainly won't refer to ICBs. It probably refers to PCTs. So you want something that's up to date. You want something that reflects the changes in general practice. So the NHS reimbursement that's now available if you take sick leave, maternity leave, paternity leave. You want PCM provisions, really important to have those. And a raft of other provisions and things to remove and change. So feel free to send over the agreement. You've got my email address. If you want me to contact you, just let me know. Happy to give you some guidance. Can we get a recording of this session? Yes, you can. The session is recorded and will be emailed to you afterwards, so you can access it. What's the cost for reviewing an already existing partnership agreement? Do members get a discount for any of your services, or does it really make a difference? So what I would say is, if you want a partnership agreement review, send it over. I'll let you know. Whether it's worth it. The BMA offer a partnership agreement review service, which is free of charge, and I can tell you how to access that. Sometimes what I get are partnership agreements that are so old, there is no point waiting for a review. You may as well just go ahead and update it, especially if you've had changes in your partnership agreement, in your partnership, that aren't reflected. I would say just get in touch and we'll point you in the right direction. BMA members do get a discount. So the figures that I've quoted to you today are discounted. And not all the partners have to be a BMA member, just one partner. So that should be absolutely fine. And I've got a few consultations. And then another one, could you please, again, briefly explain what the declaration of trust is and why it's needed? So most of the time, your property provisions will be included within your partnership agreement. Some lawyers advise that you have a declaration of trust to cover your property owning provisions. The reason why that is because a declaration of trust is a separate agreement and it sits alongside your partnership agreement. If for whatever reason your partnership agreement falls away, the declaration of trust won't. So say if you've got a partner join, you forget to update your partnership agreement, the declaration of trust, which contains those property provisions, will continue to bind the property owning partners. And that's really important because the property is usually the biggest asset or the biggest liability. So if you're not great at updating your partnership agreement, then perhaps a declaration of trust is the way forward. The other circumstance where you have a declaration of trust is if the property is owned by non-partners. So say if you've got a property owning partner who is a retired GP, so someone who no longer works in the practice, no longer a partner, the partnership agreement won't bind them, so the property provisions within your agreement won't apply. They're useless when considering the retired non-partner. So what you would have there is a declaration of trust setting out the ownership provisions between the non-property owning partners and the partner. So useful to have. Can you indemnify incoming partners against unidentified liabilities accrued under the previous partnership? Yeah, you can. You can have a clause to say that the new partner, so an incoming partner, can be indemnified and will be kept indemnified for all losses, liabilities, costs, expenses, etc., that relate to the period prior to them joining the partnership, or that arise at a later date but relate to that period prior to them joining. So you can definitely have something like that. And I think if you're joining and you're concerned about historic liabilities, then it's probably wise to have a written indemnity in there, just to make it crystal clear that you benefit from that indemnity. You mentioned modifications for managing partners. How do you identify and modify limits of your responsibility and liabilities when bringing in non-doctor clinicians into a partnership, nurses and paramedics? So there are a set few provisions that you include for practice manager partners, nurses, paramedics. One of those, we've gone through the indemnity for practice manager partners, and they usually want indemnities for any clinical claims because they're not involved in them. They have no responsibility or no say in relation to them. And you also carve out sort of clinical making decisions for practice manager partners because they shouldn't be having to make those decisions, and you wouldn't want them to either. You also, so as standard, generally GP partnership agreements have provisions relating to the GMC. If you're taking on a nurse partner, you'd have NMC provisions. So something to do, something to cover them there. There's a whole raft of different modifications that you make when you're taking on partners who aren't GP partners. They're not complicated by any means. You just need to ensure that they're in there. Sometimes if you're taking on a practice manager partner, they don't work sessions, they work hours. So you want a provision in there to say when they're expected to work, how they're expected to work, and what their profit sharing arrangements are. So are they on a fixed share? Are they on pure profit sharing? So clear provisions there, and similar provisions for nurse partners and paramedic partners. And I've just got a few more queries about the consultation. We do offer an alternative partnership drafting service where we prepare the first draft of your deed for a fixed fee, and that is £1,950 plus VAT. And then we do the rest of the work on an hourly rate thereon. It completely depends on what suits you, and I'm happy to talk through both options with you, and we can decide which one works best. But yeah, you're all free to drop me a message. And I think well, we've saved about 10 minutes, but I'm towards the end of my questions. I'll come back to anyone who I haven't answered separately. But that's it for today. So thank you very much for joining, and have a lovely day.